Say after me, sir. I solemnly swear that the evidence I shall give, shall be the truth, the whole truth.
Good afternoon and welcome to your program Kotos, where they come to you from the Society for Radio Democracy 98.1 FM. And today inside the program we'll get 1 hour discussion on the law, where they come to you every Tuesday 5 to 6 p.m. The program we they listen to na Kotos, and today on edition the program we they talk to the acting director of intellectual property, na Office of the Administrator and Registrar General, where they also for can help we talk about patent registration. In name na Yema Aisata Kuruma Esquire. Welcome to the program.
Thank you very much, Rena. Fambule, good afternoon.
Okay, continue for day with me na the studio as I will come back to you shortly. Don't forget say the program we listen to na Kotos, and it come to you from we New Englandville studio. Yourself can be part of the program today by way how you can send a text message to the number 077-981-981. The program na Kotos, and the number for sending text message to na 077-981-981. The program they continue.
Let's go. Every time I see you again, baby, booze.
You'll say after me, sir. I solemnly swear that the evidence I shall give, shall be the truth, the whole truth, and nothing but the truth,
Earlier on, I tell una say I get with me at the studio where come for help me inside this 1 hour program, the acting director of intellectual property at the Office of the Administrator and Registrar General, when I Yama Aisata Kuruma. It is also for me we can talk 1 hour concerning the patent registration way that they do at the office. First of all, you go tell me we'll talk first about the office of the Administrator and Registrar General. What's it there about?
Fambule, once again, good afternoon. Office of the Administrator and Registrar General gets a mandate from Cap 255 when at the General Registry Ordinance, we give it the mandate for do official registration of instruments. Now we get different departments there within this office. First, we get the conveyance section. We in there for the administration of conveyance. We are in, for instance, party A go buy land to party B. They want for transfer ownership to party A. So you get for go find a surveyor, then survey the land, then do then you find lawyer where they do the conveyance for you. Then you can't you can't register your conveyance. So na conveyance section and they do that. Then get other duty where they do when a deed pool. Where for instance you married, you made a name, you want to change them for carry you spouse name. So therefore they go do deed pool. Or sometimes you go do your registration NCRA, you can get mistake by your name. Sometimes you go NRN, NASIT. Then say this name here and not to the same with what you get an ID card because of the mistake. They go need for do deed pool. With other miscellaneous documents then they we NRA conveyance session responsible for. We also get what we call estate departments. We're responsible for property then where they under somebody we die in no left will. Automatically it rests in the Office of the Administrator and Registrar General and we for administer that day. But how would they know say this person don't die? Then go for come with the death certificate. The person death certificates will die. We can't tell you say this person don't die. If he left wife or picking there, if not the wife, it counts in marriage certificate. If not the picking there, it counts birth certificate for sure say you're linked to this person. So we can administer the one and day. We'll get the marriage section. We're in there for officiate wedding under the civil Cap 97 of the Sierra Leone law. We also they sell Christian marriage certificate, or they sell Muslim marriage certificate. So church and mosques, the imam or pastor go can buy to be the marriage certificate. Then they go officiate the wedding. After which they come back and can register and to be. We also get under the marriage department non-impediment. For instance, if party A in another country, then let's say France, for instance, they want married somebody there. So they need for check back in the country we come on a Salonia for sure says this country we come on, you not married there. So then they send a birth certificate, a national ID or passport to we where we they check na the marriage registry for CCS. This person, you know, we don't marry them. Then we get again what we call the gratuity section, where then they in there for administer financial benefits to person where die interstate, where die in active service. Then they again the WEF or the if you get picking and then the council birth certificate and death certificate, you can show say yes, this person where die na be my husband or na my papa. Then the main section, I go say the main section because I didn't meet the way na the intellectual property section. This section actually they do with administration and protection of intellectual property rights. For instance, you don't write a book or you don't sing your music. Though automatically it's protected, but for infringement purposes, you need for can register and to win. Or you don't do a unique symbol where you don't put by product or services for distinguishing from one enterprise to that of another. So they can again to the office, you can register. Or you don't do an invention. You don't like now, gentlemen, where we do that robot, an invention. Then when we get somebody who do electric bed, then they say an invention where they protect under patent. You can have the office, you can register. We not only centralized in Freetown, we also do at the regional. At the provinces, we get regional offices the way they Abo, Kenema, Makeni, and Potloko. So you where they Potloko, you know go say you don't buy your land, you don't do your survey, you don't get a lawyer, you don't do your conveyance, you get for all the way in Africa for can register. No, we got offices there yonder where you just sit on the register for you. We office na Freetown at 28 Walpole Street, Roxy Building, Freetown.
Okay, you there so for make we talk about the patent registration. Now people that we go to listen, we go once for know what's in this registration here so they about.
Before I go to the patents, let me just give the general overview of intellectual property rights. What's in intellectual property? Intellectual property basically gets to do with creation of the minds or your intellect. We are in a group of persons or an individual creates, for instance, or you sing a song, or you write a book or poem, or sometimes you do your unique logo, unique one with your original creation, not to somebody in thought it's for now your idea, now you take, you do. That day they can protect her under intellectual property rights. Intellectual property rights are broad. Okay. You get so many things under there. You get industrial design. For instance, this table, you see I'm saying also the normal table, they just this so it gets a shape, you get oval shape, half oval shape. So then again, you can register under industrial design. We get to do the beauty of the design of the way you do. We all landed under intellectual property rights. So the thing that we get to do with trademark, for instance, we get this water will you give me. We get anaya. I'm not going to call your name because I know I do advertisement for this company. But when you get your unique name and logo, you put on for differentiate one enterprise to that of another, where they inform the consumers out there, say yes, this person or this water now I want, not to that they want. So normally, if you go register, we get this particular water to we register already. Then you want to do similar one. I like not to the same, the similar one with the rejector. Because of it will confuse the people out there. You know, go say person now use my name for instance, say I do water Asiama. Then somebody I register I then at the system. Then somebody else can do Yema as water with the rejector automatically because it's similar to waiting in at the system and it will confuse the people out there. But we are in you get Yama for water, then this person can do Yema for phone with the register because these are distinct goods and the products and distinct. There is no way consumer go out there if you send her for go buy water, they go take phone. And not possible. We get again the copyright way. If you sing a song, you write a book, you do your artistic work. All one a day, you can protect her under copyright. Then patents and gets for do with invention where they solve practical problem. It can be a product or a process. For instance, telephone. First there will be the runner there telephone booths or within house we get land phone. You need able for answer call when you're out of your house. You got for sit down at your house for answer call. Or if you get possible oversee, we get them Seratel boots there. Where if we with the possibility oversee, we don't say it's 6 o'clock. And they call you. Then they run you go at this boot go to map the time 6 o'clock for they call you. But now the world evolve. Now we don't get about innovation. Then phone then on the smartphone then they. So now you did it anywhere in the world you answer call. So that then are innovation.
So what are the step where people then for take in terms of registration?
Now patents, you know, just they innovate. You say you don't do innovation. No, the law make provision for criteria and the way for fulfill. Forever you get a patentable protection. Now, Section 2 to 6 of the Patent Act of 2012 make provision for the criteria. The first one is for the a patentable subject matter. What in that mean? Anything where you dey invent for be patentable, that means enough for the against public order or morality. For instance, you're not going to make machine for clone human being. That's it against public order. And not patentable. Or machine where go do illicit activity. For instance, for making them fake money. There is no way to register that kind of invention. So all that is not patentable. Secondly, for be new novelty. Waiting they determine say this invention we don't do a new. Now we are in not established, you know, they out there at the public domain. Now, for instance, I carry this multi-purpose multifunctional device. Now you see here it gets the fork, here it gets the knife, and here you get the spoon for it. At first we get just the spoon, the knife, and the fork single. Now they don't carry other device, we get 3 in 1. So for instance, we're outing, one go beach. You don't need to forget the spoon, the fork, the knife. Now you don't get this. Where this part you can use them for eat. If not fried rice, you get delicious fried rice, you can able to eat with them. Then this sometimes you get spaghetti. Now you take for it. Then this side, sometimes you get use steak. We want cut. Well done steak. You use them for cutting part. So this is an invention. So if we are in, you're not able for seeing at the prior arts. Prior arts now invention the way they out there at the public. For instance, you go then at the database, or sometimes person don't do invention, then you go na radio station, you go explain all things about the invention, or you do publication into journal or newspaper, or you go na TV, you go see you talk, or you publish on the internet. That you don't fall on the prior art. That they make this invention now you go do and not new anymore because you don't did there at the prior art.
Without no registration.
Yes. Then secondly, if forget an inventive step. Waiting an inventive step. If it be non-obvious to somebody with skill in the art. Somebody will get knowledge about it. Not for deduce this invention without knowing your application, without reading your application. You get for go to and see all the details. For sure say yes, this I go able for one. But without looking at it, you just say, this, if I combine this and this, I go able for make this spoon. Or if I subtract this from this invention, I go able for do one. No, that's they should say, get inventive step, enough for be obvious. Then thirdly, enough for if it be industrially applicable. If you don't say this spoon, this multi-functional device, now industry the maker is supposed for be made there. They no go for go maker, then they not able for maker, which means it's not industrially applicable. And fourthly, if you do sufficient disclosure. When they do your application, you supposed for disclose everything by that application. Every step. Because somebody will go come, they say, because when you don't protect her, the people now will go and use and get the right time for come meet you for authorize them for maker. So then for able for maker. They no go again back, go begin, they need to explain to them. But as long as they don't see that drawings, the indication they're all long did it, and supposed for able to do this invention.
So how long did it take the process to make people then register with Una?
And it take very long time because when you can't register, again processes the way they go through. We go for do examination as to form, we do the search, we do substantive examination, we do granting, we do publication. So all that in our steps the way they take, so it will take very long time because of the substantive examination. Like the formality examination, going to take very long time because when you count the application, you go able for check them out until 1 day, 2 days, we don't accord the filing date. But that substantive examination, they take very long time. So, but however, when you don't get the protection, it lasts for 20 years. So that small money when you go pay, not go make you refuse for go register. Because when you don't get that protection, they are for 20 years. How they get them for?
Okay, so what are some of the types of innovation where eligible for patent protection?
Anything where they under technology, you can able protect them. The only thing where you know go protect and thing already they in existence, like nature, plants, animal, and they not go able for protect it because they're already existent. But thing where now you they develop with your original idea. Not if first you know you make your chair. First time they get a long bench, they will not get armrest, you know get this backrest, you know get then swivel chair there, and then they turn. Then they know me there, and just a long bench. But as long as now we see now the innovation, the way they can, they get boku different chair there. They get one way they get armrest, they get backrest, they get the other one way na wooden, the other one way they turn so all day. So then they can able for protect them. But anything where already they in existence, you need to be able for protect them.
Okay, so I take you back to the intellectual property. Now more talk about the concept of intellectual property rights.
Okay, just like what I say just now, intellectual property is vast. We get what we call industrial property, we get what we call copyright. Under industrial property, we get trademark. Why don't talk saying a sign or symbol where they affix pan goods or services for distinguishing from one enterprise to that of another. For instance, I give me name as water, Yama. Wherein you go don't put some water, then somebody else get Yema, and they similar, we go reject her. So then they do under industrial property. We also get what we call industrial design, where now the beauty of the look this table we get to see and we oval. So then in industrial design, because of the beauty, the shape, the pattern, or even this bottle here where they see so they see the pattern in para. All that they fall under industrial design. We get what we call patents, when I basically are differ, are there for. We get for do with invention, new invention. We go do where they solve practical problem. It can either be a product or a process. Process can be, for instance, Coca-Cola, the process where they take for Duan. Then again you can protect her under a patent. Then we get copyright we stand on its own.
Yeah.
Copyright basically gets for do with any protection where they give for you creation where you do. For instance, you sing a song, automatically it's protected. You write a book, you write a poem, then they protected. You do your artistic work, all land they protected under copyright. So basically that's not the concept of copyright.
That's only if they register with you.
Yes. If they register now, copyright, for instance, it's automatically protected under the law because the Berne Convention 1886 make provision for voluntary for automatic protection. So we are not members, by the way, but we replicate that section in the law. Okay. So when you sing your song, as long as it is your original idea, as long as you express your idea, not to see whether you aid because they protect you within aid. You for express and put in a tangible form. For instance, you go put on a disc or you put on a stick. Then they all you don't express it already. So you can able for protector under copyright. That not means because it is voluntary protected, so therefore you just go do any kind of thing. Then I hear say, hey, I get sing, I get this poem, I get this book, I write, and then I put no. And when you express it in a tangible form, now become protected as copyright.
Okay, so tell me you don't explain. So what are the benefits of this?
Now, intellectual property, people don't confuse say no get benefits, but it gets huge benefits. Now, when you register, you trademark, you patent, you copyright. In the first case, you get legal protection. There are laws where they protect the invention and the other creation in the way they do. Laws then they for. So that legal protection, they make you get zeal for going invest, zeal for do more creation because you know says you are legally protected. So you get economic benefit. Now, when you don't protect your creation, your invention, or your symbol, or your copyright, you don't protect them. In that protection, they give you authority for monopolize your invention. Nobody else not get right for user without your consent. If anybody use that without your consent, you don't commit a crime with an infringement, and the person will get it go sue you for that. So then they again another one way where you go get money, because when they can ask you for make the use them with the you invention, you get economic benefits out of it, or you license. Sometimes you didn't ask a lawyer, you want to let somebody else a Liberia user, you license to her. Is the user, which they collect royalty again from her. So all landed they under the importance. The other importance again, it get time frame. Like for patents, na 20 years. Imagine for 20 years they protect you. That money all you go don't spend, by investments you go don't do, by that research, all land you go don't reap, you go don't get boku profits back safe. Then you get for trademark when at 10 years. Copyright now in the day for life and 50 years after you dead. So all the protection in there, all land they under as benefits. We go get under intellectual property protection.
Okay, so if they fail for register, what are some of the risks we involve?
The law not going to fit for you. And then one. You see like this I get this staple remover now. Somebody inventor. You get her out there. You know can. Oda can register now, no. Oda can register now, they protect. Yeah? So if you get her, you left her out there, you know, can register her, anybody else go use her. That's the law need to protect you. Because you can register. The risks, you not go able for claim any benefits out of it. Because when you don't register, when you register, you monopolize and somebody not for user without your consent. So if you don't go do your invention, then you know register, then how possible for come meet you now? They don't say that you are the owner. How possible they can meet you now for say yes, I want to use this invention. Or sometimes you are licensed. How you go license? They don't know you. So now when you register, now you go get all them kind of rights then they.
Okay. Okay, so how intellectual property they protect or contribute to national development and economic growth in the country?
Now, economically, the money safe where they come in, then they make, then go use that for other investments. So you don't get another country. Like for instance, like where you go do this staple remover, then you get your money. You they go the industry na inside I go the inside salon. So economically you go don't help the country because you get for employ people there, you get for pay them, you get for pay your taxes. Economically, then they go to help the country. You go get again you trademark where you go do, you get your logo, you get your water or you get your alcohol where they do non-alcohol where they do. Then they all they bring money inside because you get for employ people there, you get for pay them. So economically then they benefit.
Okay, the program you still listen to na Koto, so they come to you from Radio Democracy 98.1 FM. I get with me Yema Aisata Kuruma, the acting director of intellectual property in the office of the administrator and registrar general. It is also for can talk about patent registration. Also I don't tell people them but the benefits where this thing has where this registration also gets to the invention them where they do. You can send a text message to the number 077 981 981. The number again is 077 981 981. The program Nakotos and it come to you from a New Englandville studio. Back to you, Madam Kuruma. Any specific law or registration or regulation day we govern the intellectual property in a salon?
Of course, we have a laws there. We govern different types of intellectual property. For instance, we got the Copyright Act of 2011. We govern waiting for doing under the copyright. Now, you get substantive provisions then for works that are eligible for copyright protection. For instance, a literary work, you go write a book or you write a poem, then they do under literary work. You go sing your music, you go do artistic work, all landed under copyright, we go able for protect. Then again, we got what we call the Trademark Act of 2014. NSF Day, we get substantive provision there of thing the way for register under trademark. For instance, the criteria for trademark, the mark for be distinctive. Like we get Yama and Yama. It's similar for be distinctive. For wearing, you get Yama for water and Yama for phone, then they distinctive. So it's different. So then they again they under trademark, and we'll get the Patent and Industrial Design Act 2012, where they for any invention where somebody do, whether a product or a process, where they solve a practical problem. Again, people can find that difficult for doing a patent because of the criteria they will get. But again, we'll get what we call utility model, when a petty patent. Wherein, for instance, you invention where you do not fulfill all the criteria of patent, then you will come under utility model. Utility model in your own criteria, they're not at. It will be new. New, I don't talk saying something when they exist in the public domain. And not they at all. When you search, we need to see and say yes. Are they under any database, or somebody we don't publish or somebody we don't do some kind of TV presentation or conference presentation. And not they. Or the second criteria for utility model and industrial applicability. For be industrially applicable, wherein you do the product or the process of the invention, it will be made in an industry.
Okay, so what's important for do if they thief in patent?
Now, when you don't register your patents with me, the law again they for infringement. Wherein somebody use your patent without your consent, that you don't do an infringement. Section 71 make provision, or Section 71 of the Patent and Industrial Design Act 2012 make provision for infringement. Where you party A or party B, you know say me and me get this invention, then you knowingly go thief am without me consent and authorize you for doing, then you don't commit an infringement. Now, Section 72 they give the civil remedies for that. For instance, then go get injunction. We are in the courts, you go to the court and find you say yes, indeed you do that infringement. You pay damages. Damages for that person, because you don't do that infringement, you don't make that person, they don't do so many losses. You know, sometimes the sell way for selling, they will sell. Because of you, don't go make that invention. Then you will also pay in legal cost. The money we pay for get lawyer or for going to court.
So now I can get that money there.
No, not. That's what we get out. That's what we get out. The applicants, the owner, you have to get invention and then they give to. Then you get criminal remedies where at the same time, if you go thief this person in invention without knowledge, that you don't commit a crime. Where if the court find you liable, they pay 60 million, all use. Or you go 3 years imprisonment for patent. For copyright, 60 million and 1 year imprisonment. For trademark, you get 5 years imprisonment. So all them provisions and they for infringement, wherein somebody else will use the intellectual property creation without your knowledge. All them provisions and they.
Okay, continue for day with Win at the studio. We'll go for a short music break, and when we come back, the program will continue.
Yo, we country slow, we want for no, why not they grow? Yeah, hey, bo, we want for no, wait make we country they go slow, wait make it all they grow. Yes, so oh, I can for sure, yes I can for sure them thing them way they make we know they grow. Say now we they like one, if I they try for go before, I beg bo. Do ya not make us slow? No. If I try for raise the tempo, do ya not make them low? Yes, so. If I try for go before, I beg bo. Do ya not make us slow? No. If I try for raise the tempo, do ya not make them low? Yes, so. Before they do them thing now we go make we gladdy, thing now we go make we happy, thing now we go make we country laddie daddy. So we go live in unity. Yes so. Before they do them thing now we go make we gladdy, thing now we go make we happy, thing now we go make we country laddie daddy. So we go live in harmony. Yes so. Don't we for do them thing now we go make we smarter, thing now we go make we stronger, thing now we go make we nation last much longer. So we life them go better. Yes so. But we for left them thing now we go make we scatter, thing now we go bring palava, thing now we go make we nation well panambara, make we people scatter.
Scanty that you talk about. I'll let them.
Thing them like half flavor plaba, political party wahala. Thing them we go make we agba, them put we country pan yakba. Sing along say hey, hey bo bo, we want for no, waiting make we country they go slow. Waiting making all they grow. Yes, so oh, I can for sure. Yes, I can for sure them thing them way they make we know they grow. Say now we did like yes, so make we show them thing now we go make we kick boom. Thing now we go make we country go before. Mama, yes, so now we go make we grow. Thing now we go make we left for go slow. Make baby gladly for Bobo show. Alright, so if I perform, me on perform. You say for gladly for what you watch. If I they sing, me young sing. You say for gladly for dance, you dance. Before they do them thing now we go make we gladly, thing now we go make we happy, thing now we go make we country laddie daddy. So we go live in unity. Yes so. Before they do them thing now we go make we gladdy, thing now we go make we happy, thing now we go make we country laddie daddy. So we go live in harmony. Yes, so sing along, say hey, hey, bo, bo, we want for no, waiting make we country they go slow, waiting making all they grow. Yes, so oh, I can for sure. Yes, I can for sure them thing them way they make we know they grow. Say now we did like pampo.
We did pray, but still things not the change. How we go before when we still get even ways. Let we try to change your way.
The program where you still listen to Nakoto, so they come to you from Radio Democracy 98.1 FM. Still get inside the studio with me, Yema Aisata Koroma, acting director, intellectual property at the Office of the Administrator and Registrar General. They are so for talk about patent registration. Back to you, Madam Koroma. Now we will talk about the legal framework we govern the intellectual property rights.
Okay, Fabule, just like what we said just now before we get the break, we got the Copyright Act 2011, we got the Patents and Industrial Design Act 2012, we got the Trademark 2014. We also get legal framework of international agreements and protocol with Salon are part of. For instance, the Harare Protocol, we get for do with patents with somebody, Sierra Leone and Godea, because we're a member of ARIPO, Sierra Leone and Godea, they don't do invention, they want to get regional protection for different countries then. So you go through ARIPO, get one application and designate different countries then when a member of ARIPO. That's get for do with the Harare Protocol. We also get what we call the Madrid agreements with Salon are part of. Then they get to do with international registration of trademark. For instance, you go in a salon and you don't do your national registration of your mark. Then you want for protector and a different international countries. Mind you, Harare for regional and for Africa. Then you get WIPO, where you go through for Madrid, forget international. For instance, you want one in Switzerland, you want one in UK, you want one in America. All member states, the way they now the Madrid, where you go on for designate for protect your mark. If they go to the Madrid agreement, you go to WIPO, file one application. In fact, now we office, as long as you don't do that national registration, you can't be now. We they file application there for you. You designate to different countries there. You pay when one application designating different countries there. We also get what we call the TRIPS agreements, which are also now part of we get for do with trade related aspects of intellectual property rights. all land in the legal framework for intellectual property rights.
Okay, so waiting different from the process them, the registration process from Salon and international standard.
Salon, when you can, na national, na 1-for-1. When you can, na just Salonomo, you dey protect its territory and Salonomo. But when you go for international, you dey able for Dex, you dey use one application for different countries. You go able to designate 5 or 6 different countries. So, but when you can, na Salon, na just Salonomo, na the national application. So that's the basic difference for Salon and international. The different countries the way they designate, but the rules, the trademark for be the same, or the invention, if na Harari protocol you dey go through, you got for be the same. Not for different from which you go protect under the Harari protocol, different from which you protect now, all things for be the same. Just that the countries the way they designate, and different countries there, where you want your invention or your trademark be protected under.
Okay, so now make her go inside the inbox and read some of una text message them way una don send for make Madam Koroma go able for answer to una. This one say, good afternoon, Madam. Wetin are the money we involved for make we register with una? This other one inside the program say, show we also we go able for locate una office. The other one inside the inbox say, Madam, plenty time we don't see people that they make allegation against them competence, say then thief the music. What do I get for say but that? Well, I then text message there so they for so you go answer to.
So I go start with the first one. We say, waiting at the money we involved for registration. These texts are not stated categorically clear whose IP it refer to, whether a trademark, whether a patent, whether a copyright. So basically for trademark, you did pay 300,000 for application. Like you go don't get unique brand, you want can register. With that application that you did one, you come, they will do the formality examination for know whether this brand will intend for register, if it ain't at the system or not. 300 for that day. Then when we don't approve her, you go again, you go pay 600 for the register. Landing at the registration of the brand. Then for patent, na 5,000 and na 5 million, na small money. Because look like trademark, you don't pay all land, then you protection they last for 10 years. Then patents, you go pay 5,000, where you protection they last for 20 years. However, you go for the do renewals. Like trademark, after 10 years, you they renew. Can pay back small money. So the benefits and will pass the money safe what they take. Then copyrights now 1,500 and they pay for copyright. 1,000 because don't reduce now. We don't pull the 500 just for now encourage people and for can register. Then the other text they ask waiting at the location of the office. The location for Freetown office at 28 Walpole Street, Roxy Building. Just after now, if it's a bit cutting tree, you cannot sit, then the other building, and they meet Office of the Administrator and Registrar General. So we also get regional offices there now.
So when people go now in our office?
From 8:30 to 4:45.
From when to when? The day?
Monday to Friday.
Okay, well, the program is still a listen to Nakoto. So they come to you from Radio Democracy 98.1 FM. Madam Koroma, how school or media institution go able help for promoting awareness and intellectual property?
Well, this now one would they do so. The opportunity one they give it for CAM and CAM for can do this awareness raising. Because they find out say but people don't know about they don't know about intellectual property rights, they don't know the benefits, they don't know the processes, they don't know what's in intellectual property rights. So media house now they give you the opportunity to work on and not charge you money, small money, no. That's the opportunity when I go give you. Let us say voice out wetin na this intellectual property, wetin dey about.
So una
wetin
get for
everything
come and come partner with we.
Go for
This na just cutos where we invite una. So una go get for come and pay for partner with the station. So we go get money. Like how una sef dey get money.
Not only they get the money, not only the office. The funds they go na the consolidated fund because then they pay to NRA. So
Okay.
they go na the consolidated funds. So not only they get the money. So but Madam, they listen, you go here, and when I heard the initiative go to her.
Okay,
And I
no
get forget
problem.
the MOU, the memorandum of understanding. Then we go partner with una.
No problem.
We una self go do go na use small money.
Okay. So you get any advice where you go give to young innovator them on the entrepreneurship where they listen to you right now? You get any advice for them?
Yes. Now young innovators there. When una do una invention, una not just go out there, go publish an newspaper or go do talk na, go display a conference or go na TV station, the publisher. The criteria the way this invention gets for let be patentable. The main one na novelty. If you see you don't lost standing, you don't lost everything. Because if you don't publish, I don't in the public domain. Or you don't call like once you don't say I do my invention, I don't can explain all thing about what I do. Then in an oral disclosure. All thing on the out there in the public. Then you're not go able for that novelty criteria, you don't lose her. So definitely you don't lose the invention. We need able for protector. However, exception then at the law, where we are in, you do that. For instance, you don't know, because now the awareness and not much. But we are in, you don't know, you can a radio station or you go publish on some kind conference or you do some kind oral disclosure. You get 6 months within that period for let go protect you invention. After that 6 months, that's it. You don't lose the novelty requirements. I think you need able for protector again because you don't out there in the public domain.
Okay, on the enforcement, more look at that side the back for people who they thief. Anybody in work we don't do, more go that side the back. Make people waiting at the punishment where they go get.
So infringement basically now we are in party A use a protected invention or a protected trademark without the authorization of the inventor or the creator. That means you don't commit an infringement. Section 71 of the Patent Act of 2012 make provision for infringement where you knowingly you infringe on somebody in invention, in patent, or in trademark, for instance. Then Section 72 make provision for civil remedies. Wherein you don't thief person in invention, then can you go to court, then find you wanting, you dey pay damages. That money where that person for don't get, if you know me don't thief in invention, you dey pay that money, they cut the calculator, you dey pay unto the inventor. That money where that person use for do this court proceedings, now you dey pay, for take lawyer, for go court, for pay all lengthy and day, now you the infringer, now you dey pay that money day. You get all land. Then we'll get injunction where the courts go give. We are in something, you they make this staple remover. Then you dey in the process, or you get the building where you need to do all land. The courts can go there. Then go either then destroy all the instruments that we get for doing, or then stop you for any imminent production we go and do, and they stop you not for doing. We get again the civil remedies where the courts go give. You they pay 60 million. Or you go 3 years imprisonment, we get for do it a patent, or you pay and go the 3 years imprisonment, both. It is either you pay the money or you do the term of imprisonment, or
Just
both.
depend.
All both for patents. Then for trademark na 5 years, then you pay the 60 million. The same with copyright. Copyright na 1 year. Then 60 million, all use.
Okay, now we'll talk about the challenges them in terms of patent. What are some of them challenges there?
The challenges are many. So we find out say we need to get a patent application because of the drafting of the application. It is very, very technical. Now, when it comes to drafting, you get engineering background because you get drawings there. You get for show how the invention relates to the application where you do. So one that in a one way lawyers and even the technical people like, can find difficult because the claims span the patent application now in they determine the scope of protection. You got to specify every little thing of the invention. All thing where they pan that invention, you got to specify, if possible, you give drawings and show how they relate. Now, in unity of invention again gets for do with that day where you not go just sit down, you make the application, you make one invention where no relates to the second one. All for relates. For instance, you get this pen, you get this cover, you get the beak inside, then you get this cover. Yeah. So all three then instruments and therefore relates to one invention. You not just they go this stand on your own, or then they stand on your own. Or you make this chair. You get the armrest, you get the backrest, you get the limbs. All for relate. You know go take the armrest, you put on one. So all on and then challenges where then they get for this patent registration for do the application. That's now one. Two, the classification of patents. Now because mostly people like can do trademark, so then if you say no more, not just trademark classification, I go use no. This is different. Trademark they use NIST classification. For patents they use the international patent classification. Indifferent. They get in sections, they get subgroups, they get main groups, they get in classes the way they do. So each invention they fall under section, again main group, again subgroup. So they can find that difficult for do online classification and then when you come to the administration side, where they get challenges with technical expertise. Because for make we do the examination, for do the prior art examination, it's very technical. So normally what's in we can do now just formality examination. The way the event or counting application, with the examiner for CCS, it gets it puts a name, it puts the date, it pay the required fees. With CCS the request day for show says you want to register your patent. That's at the formality examination. Now for the search for prior art, that's for
I would just want to ask you, how people let it go about for search in terms of patents.
So like we don't do the formality examination, would they inform you, they notify you, say yes, you don't fulfill this formality examination, would they accord a filing date to you. Then you, the applicant, is sending a request to the registrar for say yes, you want for make them do search for prior arts. The International Search Authority. We forget the International Search Authority, they plan forget ARIPO, we go able for they do that in the for me. Now this search how then they do how then go for they do basically then get databases. For instance, you go use SpaceNet or even Google, you can use for do the search. Now when you search, you do this invention, a multifunctional device. When you search, you enter the key parts there. The key parts and they enter for see if other documents then they where they should say as this is not new. So then documents and they when then come up, then they compare and contrast this intended invention with the one where they in the database for sure says different or is similar. If it's similar, then they know says this is not new. If it's different, then we know says this is a new invention. Then you can able now for go to the next step when an inventive step where then they assess for sure says this invention it fulfill this criteria.
Okay, when I get any organization or resources we available for patent registration?
Except the regional and the international. Yeah, for Salonia, would they write? Go see if they go help. But for regional, we get ARIPO because they can get then distance learning and they get training there where then they do for help for drafting. Where then go car, they'll tell you all the processes how for one and show you how for draft from the title to the claims. And they show you how for draft all there and in there. So we get ARIPO, then we get WIPO again, we can able for assist on how for do the drafting again. Because it's very technical. The drawings get for relate. Everything get for relate to one invention. So we can get there and in there because they know the expertise there. Then get so many people that we get technical knowledge. So they can able for help we for know how for draft then application there.
The program is still a listen to Nakoto, so they come to you from Radio Democracy 98.1 FM. Get with me still inside the program, Yama Aisata Kuruma, we are the acting director intellectual property na the office of the administrator and registrar general. Continue for sending text message to the number 077-981-981. The number again is 077-981-981. This one inside the inbox say, Madam, I don't miss half of the program. You can lay more emphasis on the framework we govern Intellectual Property Act. This other one say, Madam Koroma, una really they do a great work, but a better way una don't begin come na radio we don't dey understand the work we una they do. This other one say, thank you to the administrator and registrar general because of a good initiative where it come with na this office.
Okay. Famulona, thank you, Una, they listen to this program. Now, there was another question we will not be answered to before we go. We'll get allegation of music, how we able for tackle am. Now, music, the law say it is automatically protected. That's the provision of the ban convention of 1886, where Salon replicated that provision. The Act of Copyright 2011. It is automatically protected. No means say you know for register. So there are allegations there what they get from music. If they not can register, how we go able for protect this person? The legal framework make mention for people the way they can register. So the registration are basically for them in there. Where somebody go to music. So how go able for protect you if you not register? We not get nothing about you. What's in the show says and you get this music. Normally they can't deposit her. So we say yes, now you get this music. But waiting go able for show nothing. So in the case we are in a register, they will go able for protect her. But we are in a non register, no, we need it able. So this they ask to say miss the framework for IP, the legal framework for IP. So I go over that again. As I say, we get the Copyright Act 2011. We make provision for the protection of copyrights in a salon. For instance, you get your music, you sing your music, or you write your book, or you do your poem, then they can be protected under copyrights. Now, copyright is not just they sing. If you say yes, you don't sing, you don't protected, you got to be original. You need to go see first your music. You can't sing. I say na you know, no, an original one, na him for be protected. Then if you express your ideas in a tangible form, that your ideas don't just stay in your aid. If you say yes, you don't get copyright. No, express and go sing and write and down the lyrics, sing and put on a disc, put on a flash drive, then they will be protected under copyright. Then you get your book, you get your poem, you get story, you get artistic, then drawing there. All land they will be protected. We get again what we call the Trademark Act of 2014, where then they get for do with sign or symbol where they affix a product or a services for distinguishing from one enterprise to that of another. For instance, I use my name as Siama because I don't do advertisement for company, they don't pay me, so I'm not going to do that. So I use my name as Siama. We are in Aputa Panwata. Then somebody else go do Yema. When you come for car register, the law say you know for register similar trademark we go cause confusion out there to the public, so they reject her. But we are in a do Yama for me your name for me water, then somebody else can register the same Yama self for phone, a distinguishable, so you can able for register. We also get the Patent and Industrial Design Act 2012, we make provision for inventions, protection of invention. You you don't do invention like that, but we do that robot. That gentleman, sorry, my dear, that gentleman we do that robot where it will come, a camp protector under patent. Or that gentleman, one gentleman give do electric bed. So then they again you able innovation, you able for put under patent. We get international framework, the legal framework. We get the Harare Protocol. We get for do with regional protection. to member states there will be where they inside the Harare Protocol, where they part of ARIPO. Salon are part of ARIPO. So that Harare Protocol they in there for patents. For instance, if Sierra Leone and they don't do this invention for that electric bid, they want for registrar at different regional countries, then we're part of ARIPO, okay, able for register and they. We'll get again the Madrid Protocol, where Salon are part of. So then again, if you get to mark, you trademark or you symbol where you don't register now, they want for designate different international countries then. You don't go to Madrid, we go get them. So that's not the legal framework. Then we also get the regulations there. What we don't do, we get the trademark and we get the patent regulations for 2024. When they spelled out the processes, how for go about for doing the registration.
Okay.
So online framework then there.
Okay, as we dey round up the program, wetin are you advise to different people there where they do innovation, because like plenty people not get the understanding for go outside them for go for make them go able for be protected, make them innovative thing then be protected. What are you advise to them innovator?
So Fambule, I go my advice now basically we got innovators, we got people that way inclined in anything and the way they do work innovation, but because of the lack of awareness, make them no get that kind knowledge. However, when you do innovation, no publisher without protector, you lost the criteria of novelty. No go display my conference, you lost the criteria of novelty. And when you don't lost that criteria there, you need the able for protector. And when you innovate, go now the office at 28 Walpole Street, Roxy building with the able for protector under patent. Not allow anybody, let us give money safe, because that protection way they get lots of money per that small money where they go give for go publisher or for go put on a conference, put on a newspaper. No, you they loss because the benefits and patent protection a bokun. And the time of protection are 20 years. Imagine you get you invention, you monopolize them for 20 years. Nobody else not get rights for user. Now you want to get rights for user. Anybody will user, you go able to sue that person in a court. All that kind of royalties, the way they come in. Now you want green they get her. So that benefits the ibokun. No go see dollar, go possible give small money, go confuse you, give small money, you lost them criteria and they.
Okay, plenty. Thank you to you, Madam Yama Isa Takoma, we are the Acting Director, Intellectual Property, Office of the Administrator and Registrar General. You don't deal with me inside the program for this 1 hour way the program na Kotos. Plenty thank you for joining me inside the program today.
Thank you very much, Mr. Rena. Thank you, Salon people, for listening. We'll continue for the can't forget today. Awareness raising.
Okay, no problem. Well, now this edition of Kotos go left you for today. Plenty thank you to my producer Mangi Mansare, to the technical team Fatmata Samura, we don't show it live on Facebook, and to DJ Caps for in support. Me we bring to you this edition of Kotos today. Me na Theodore Arena. They say have a blessed evening. Bye bye.
I see la vida.
The Society for Radio Democracy 98.1 FM.